Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Well, today is Monday, February 15th. It's been a crazy, crazy weekend. Video I posted, last one regarding Missouri Supreme Court hanging medical marijuana attorneys out to dry, just absolutely blew up. That was published on Friday and it went insane. So there have been a lot of questions that have been raised by people after that, and people took part of what was said and ran with it. So I want to address a couple things. First, the clarifying comment on Rule 4-1.2 is a clarification of how the court is going to interpret that rule. So it's not a change in the rule, and that's one of the concerns. What it is it's an expression that the court is not going to consider the amendment to the Missouri Constitution that is now Section 1, Article 14 in their analysis of what an attorney can and cannot do. So that's very concerning to a number of attorneys. Now, one thing you have to understand, and a lot of people seem to take the impression that this is going to affect criminal defense. It does not. In criminal defense work, you're not counseling a person how to do something. You're counseling them after the alleged offense has already occurred. Okay? So criminal defense work is a completely different animal. This is not going to impact any criminal defense work. It may impact the attorneys that are representing the medical marijuana businesses on appeals, for license applications, for the next round of license applications when they come out. Okay, that's where it gets questionable. However, since that video dropped, and part of the response to that is the email that I received that had a presentation in it by an attorney I know and I've trusted very much. He's an excellent attorney. Implied that this happened on Friday, which was rather concerning. However, since then, other attorneys have said, no, this actually happened in summer. So when that comment was amended and added, I don't know. The Supreme Court does not date the comments that they post, that they append to the rule. A rule change is dated, but a comment is not. So I don't know when that was added, and I assumed from the other attorney's letter that he was aware, but this may well have been during the past summer. If that's the case, I'm not aware of any attorneys actually having been called out for discipline under the comment to the rule. So under that situation, I'm not aware that any attorneys have been flagged for discipline for their representing medical marijuana companies. However, they could be. So attorneys are going back and forth, and the various defense bar and the medical marijuana bar has been discussing, well, how do we respond to this? What do we do? And one question is, perhaps we do nothing. If the Supreme Court is not interested in enforcing that at this time, which it does appear since it hasn't been, there's probably a reason for that. Well, one of the reasons may be that there's still a federal moratorium on prosecutions if you're acting under the guise of state law. However, that doesn't change the language. And the language of the comment says that you've violated your oath and you could very well face discipline. So just because they're choosing not to enforce it doesn't mean they can't. The second thing, and probably the most important part of this is a continuing progression of the Missouri Supreme Court stating quite plainly that it will not be bound by the confines of the Missouri State Constitution, and that the peons that vote for such cute things, quaint measures like ballot measures to amend the Constitution, aren't going to tell the Supreme Court what the law in Missouri should be. And that's a rather snide way of saying that, look, the court has in the past already essentially nullified a citizen-led attempt to change the Missouri State Constitution. Amendment 5, which became Article 1, Section 23 of the firearms law, was quite clear. And then the Missouri Supreme Court decided that it literally had no meaning. If I'm not going to get into that too much other than what I just said. If you have questions about it, I'll do a video on those two things and what that implies for future ballot measures and issues in front of the Missouri State Supreme Court. Because it is creating a situation where if you can't count on the Constitution being followed by the state Supreme Court, what can you count on in Missouri law? And at this point, you know, you've got to wonder, fuck, man, I don't know. Maybe the next court decides that we don't need to follow anything in Article 2, or the Constitution doesn't actually limit state government from doing whatever the hell it wants. We don't know. So that's one way to look at that. Another way to look at it is the Missouri Supreme Court was using that comment to signal to attorneys, hey, you need to rein it in. You swore an oath to follow the law and support the law, and now you're out here running around violating federal law. And that is contrary to your oath. Which begs the question, does that only apply to attorneys prior to the passing of Amendment 2? Or does that also apply to attorneys who were sworn in after Amendment 2 was Missouri law? Again, there are no easy answers in law. There are no 16-minute, this is everything you need to know and we're done. Okay, so what does this primarily affect? Primarily, this is going to impact attorneys who are owners or investors in medical marijuana businesses. They are at risk, and attorneys who are currently handling and advising medical marijuana businesses. This is not going to impact criminal defendants at all. This is not going to impact patients. Since I don't know of any patient that seeks an attorney's advice before getting a patient card. However, to the extent that they do, I don't think you're violating federal law if you tell somebody, go get your patient card. So, to that level, I think that it's not going to impact the patients and criminal defendants at all. However, it will impact the ability to counsel and advise caregivers. I know a lot of caregivers have asked, well, what do I do here? How do I contract? And it's going to impact that, because caregiver, even though Missouri law says that you are handling the patient's medication and assisting them, under federal law, it's in your hands. You are distributing marijuana. So that's, caregivers are going to be left on their own too. They're going to be in a gray area. Now, do I think that a caregiver's really at danger of an FBI raid? No, I don't. Now, I had a great discussion about all of this with Nate Bowman on Nate on Cannabis, and you can go check out his channel, and you probably should if you're interested in the topic. The big issue here for me and for a lot of lawyers is actually not so much the medical marijuana component, but the fact that the Supreme Court is seemingly ignoring the parts of the Missouri Constitution that it doesn't like. And that's a very, very big problem. That means that we are actually losing the rule of law and not protecting Um, and for everybody who thinks that the solution is, well, just sue them, file a case, sue them. You can't really do that effectively. How do you sue the Supreme Court in your state? In one of the courts in your state, and then it gets appealed up to the Supreme Court to make a decision. So somebody sues for declaratory judgment, and that this comment, that read, is unconstitutional. Well, if an attorney hasn't been sanctioned and disciplined by it, that may be a moot point because it hasn't actually happened to anybody. Second, you run through the entire appeals process, it gets up to the Missouri Supreme Court, and the Missouri Supreme Court says, no, we think we got it right. Thank you. You essentially have no recourse here. So there is no recourse in law for attorneys. There is, however, recourse in politics for the populace. Look, Missouri State Supreme Court judges face retention votes. You can speak in your vote on retention. I'm not going to say whether you should or you shouldn't, but that is a recourse for the citizens. But it is a tough situation. And the people that say, well, file a suit in federal court, think about that for a minute. You're going to ask a federal court, which can't tell the Missouri State Supreme Court how to interpret Missouri law, by the way, but setting that aside, you're going to ask a federal court to tell the Missouri State Supreme Court that they should not tell attorneys that it's inappropriate to advise people to violate federal law. That ain't going to work out well. So, while the concern is there, and it is a very, very serious concern, this isn't an end-of-the-world situation for medical marijuana consumers, and that's something that you need to know before you get in a panic, drive your anxiety up, and you need to spend the next week. Well, maybe you want that. Anyway, so the essence is that this is something that you need to pay attention to, but it's not the end of the world. This is going to impact the industry, and it's going to impact DHSS. If the Supreme Court decides to enforce this against the industry, it also has to be enforced against the state, which means Department of Health and Senior Services attorneys aren't going to be able to advise Department of Health and Senior Services how to operate a medical marijuana scheme that violates federal law. That's going to deprive everybody of an attorney in the process. The state can't appear in court. The companies are supposed to be represented by counsel, although there may be an allowance for a president to appear, or one of the officers to appear on the company's behalf. Honestly, I haven't looked at that recently. But if the state can't appear without an attorney, then that's going to make for some real interesting cases, won't it? All right, so that's the update. There's going to be attorneys getting together, talking about what to do about these things for quite some time. When there's an action by anybody, whether it's a suit by medical marijuana attorneys, or if it's we hear about a discipline process, we'll talk about it. But for right now, it's a lot of smoke and noise and not a lot of real concern for the medical marijuana consumers. The businesses and the medical marijuana attorneys need to be very worried, but the consumers do not. Thank you. Hit like, subscribe. I'll be talking again real soon.